Good evening. The May 18th, 2023 regular board meeting is being recorded. Anyone wishing to observe the meeting may do so via AVUHSD's YouTube channel. Individuals may take photographs or record meetings, provided the individual's conduct does not constitute a disruption, including obstructing the view of all others. Roll call. Ms. Corona.
Present.
Mrs. McGrady.
Present.
Mr. Sanchez.
Present.
Mrs. Nguyen. I'm here as well. Mr. Delgado, student board member, is not here at this time. All right, 2, governance workshop. Public business from the floor, governance workshop. Government workshop, Brown Act, presented by Anderson, Adelson, Loya, Rudd, and Rummel. You're up, sir.
Good afternoon, board. How are you today?
Great, good afternoon.
All right, so today I'm going to present to you on the Brown Act, the open public meeting requirements under the California Education Code, and the Brown Act can be found under Government Code 54950 at SEC, or in layman's terms, all of the code sections that follow 54950. So our agenda today, we will look at the intent and general rule of the Brown Act, what constitutes a legislative body and members under the act, what is a meeting for purposes of the act, the procedures for public meetings and public participation, closed session, enforcement, and some recent additions and changes to the Brown Act. So what is the intent of the Brown Act? To be found at 54950. Purpose of public agencies in this state exists to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and their deliberations be conducted openly. That is the purpose in terms of they want your actions and your discussions regarding district business to occur at a board meeting, in open session, in front of the public. Really, it's to facilitate public participation in local government and also to curb misuse of the democratic process by secret legislation of public bodies. Back in November of 2004, the voters of the state adopted an amendment to Constitution Article 1, Section 3B, which added the requirement that both the meetings and the writings of public officials be open to the public. When we are dealing with something regarding the Brown Act, it is interpreted by the courts to be in favor of public participation and, more importantly, governmental transparency. So here is the actual rule. All meetings of the legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency except as otherwise provided in this chapter. And so if an entity fits within the definition of a legislative body, then it is subject to the various requirements of the Brown Act. Absolutely, please do.
Absolutely. That's open to the public as well.
Technically, yes. Now, there are exceptions in terms of certain things that are considered notes or memorandum, but generally speaking, the writings of the board members are subject to disclosure.
Okay.
There are certain things that are within exceptions, and we will talk about that. But generally speaking, yes.
Thank you. Thank you.
Any of your writings that relate to district business, right? Obviously, there are certain things that will fall within different exceptions, such as attorney-client privilege, something related to personnel, something related to a potential student matter. Closed session items are not subject to disclosure in terms of your writings. And we will talk about closed session. But just generally speaking, the idea of the Brown Act, and it kind of goes hand in hand with Public Records Act, is the idea that your writings, things related to district business, should be transparent and open to the public. Was there a follow-up question?
No,
Ms.
no,
Hunt?
thank you. I was just, like I said, I just wrote a note to myself.
Yeah,
to
I mean, again,
ask you.
I would say certain notes are going to fall within the exception, but I do think it is important to have that sort of general rule in your background that things related to district business could be subject to disclosure.
So my text to Mr. Nehan could be.
Absolutely. Absolutely. I'm actually dealing with a matter for another district involving text messages.
Wow.
So very simply, the governing board of a school district is considered a legislative body for purposes of the Brown Act. Some other examples would be a city council, a JPA board, an ROP board. Also, some of the subsidiary bodies of a local agency could be subject to the Brown Act requirements. Things that are not legislative bodies are something known as an advisory committee. So if the board wanted to put together an advisory committee related to the hiring of a particular position, or if there was a real estate opportunity that was available to the district, and there were less than 3 board members on that advisory committee, that is not considered a legislative body and would not be subject to the Brown Act. The exception to that particular rule is what's known as a standing committee. A standing committee of a legislative body, irrespective of their composition, which has a continuing subject matter jurisdiction and has a fixed meeting schedule by resolution or other formal action, are considered legislative bodies for purposes of the Brown Act. I have many districts that will have what's known as like a finance committee, right? It's an ongoing committee. Typically, there may be 1 or 2 board members on that committee. That type of committee is subject to, if it's been done by resolution or some other formal action, is actually subject to the Brown Act. And so they would have to post an agenda in advance. They go through the typical rule and processes that you would see here at a board meeting. Now, what is a meeting? A meeting is considered under the code any congregation of a majority of the members of the legislative body at the same time and location. This includes teleconference locations as permitted by the code to hear, discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the board. The definition of deliberate includes the collective acquisition and exchange of facts preliminarily to an ultimate decision. An action taken means a collective decision by the majority of the board. This also means a collective commitment or promise by a majority of the board members to make a positive or negative decision, or of course, a formal actual vote. So all of those things fall within the scope of what is considered to be action taken by the board for purposes of something being considered a meeting. What is not a meeting? Individual contacts or conversations between members of the board and or any other person, attendance of a majority of the board members at any of the following events are not subject to the Brown Act requirements, as long as the board members do not discuss specific district business amongst themselves, other than what might be scheduled as part of the program. There are 6 examples. The first is a conference or similar gathering open to the public that involves issues of general issues, interest to the public or the school board. Best example I can give you for this is the CSBA conference, the annual conference. Obviously, many boards go, full boards or majority of the members attend, or an AXA conference. That would be something where a majority of the board can attend and it's not considered to be a meeting. The next would be an open publicized meeting organized by another person or organization other than the district to address the topic of local community or concern. So if there was something happening in the community regarding something and there were more than 3 board members there, that is not considered a meeting. Again, the key though is that the members cannot speak amongst themselves about any issue that falls within the subject matter jurisdiction of the board. An open and notice meeting of another body of the district, that typically doesn't become an issue. an open and notice meeting of a legislative body of another local agency, such as if you all went to attend a city council meeting, majority of the board can do that. Again, you'd have to refrain from discussing amongst yourself district business, a purely social or ceremonial occasion, such as a birthday party, a wedding, something of that nature. And the final one, this is the one that I get a lot of questions about, is an open and notice meeting of a standing committee of the board, provided that whoever is the third, fourth, or fifth board member who attends, they only attend as an observer. So they have no ability to participate. They should not comment. They should not ask questions. They literally, as they say, they should be a fly on the wall and simply observe the standing committee meeting. As soon as that third person participates, we now have a Brown Act violation. Right, and typically when you're dealing with the standing committee, usually there's one or two board members already on the committee. So. Right, but still, if you get the third person there, now you have, yeah. Correct.
Sit in the back and just not say anything.
You would have to sit in the back and not participate in any fashion. No
Might be a little
questions, no
hard for me,
comments.
but thank you.
All right, one of the other issues we see a lot before board members is what is a serial meeting? And so a serial meeting is a majority of the members of the board shall not, outside of a meeting authorized by this chapter, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business within the subject matter jurisdiction of the board. What is not a serial meeting is, for instance, best example I can give you is that Superintendent Nehan may engage in separate communications with the board members outside of a meeting to answer questions or provide information, as long as he does not communicate back to other board members your position or your information regarding that particular subject. I've got a few slides here, I think, that are visually help folks kind of understand. So this would be the example where Superintendent Nehan and or his staff would send out information to the board. And it could be done all in one email, right? Everybody's on the email together. That is okay. That is permitted. Where we get into trouble is after the information is sent out, board member 1 calls board member 2 to discuss, board member 2 calls board member 3 to discuss, and board member 3 calls board member 4 to discuss. Here, 1 never talked to 3 and 1 never talked to 4, but we still have a problem because we have more than 2 board members have discussed the issue outside of a meeting. Next would be the prior example I gave, the dreaded reply all. So Superintendent Nehan has sent out the email, the information to everyone, and one of the board members replies back to the email, and it has all the other board members on there. That would be considered a serial meeting, because now you have communicated with more than one board member on the subject matter. Yes.
Can I ask you, and sometimes people have said they just didn't mean to reply all, and they just hit so is there a cure and correct?
So if there is a situation where there is a reply all, typically Superintendent Nehan would reply and just remind you all not to have any further discussions. One of the ways that it can be avoided is if the information is sent to you and you are BCC'd as opposed to in the Ray line or in the to line, because you can't reply all as a BCC.
Oh, okay. Thank you.
Can I just clarify? Rachel and I always send communications to the board BC for that reason. There are some occasions where board members are all emailed by someone. Sometimes I'm included, sometimes I'm not, but those would apply as well. So it doesn't matter. It doesn't matter if we staff as the sender or someone, if you reply all, it still counts as a meeting by email.
So never reply all.
Correct.
Send it to Greg.
That's a great rule.
Forward it to Greg.
All right, let's talk a little bit about public meeting procedures and public meeting participation. So notice of meetings. For regular meetings, the agenda must be conspicuously posted, at least 72 hours prior to the regular meeting in a location that's freely accessible to members of the public. Obviously, in today's day and age, you are posting it online, but you still do have a duty for those who may not have a computer for you to post it somewhere here at the district office where it is easily viewable for the public. I'm sure you guys probably posted on the front door or somewhere in that vicinity. The agenda, the descriptions must reasonably inform the public of the matters that will be considered with sufficient details for members of the public to determine whether or not they want to participate in that particular meeting. A special meeting may be called by the board president or by a majority of the board. The notice of a special meeting must be posted at least 24 hours in advance. And the board can only consider business that is listed on the special meeting. I mean, typically that is why you're calling a special meeting, right? It's something that can't wait until a regular meeting. So you only address what is on the agenda for the special meeting. There is no requirement to have a general public comment. The public comment needs to pertain to the agenda for the special meeting. You are allowed to also have closed session as part of a special meeting. Public participation. Members of the public must be able to address the board regarding items on the agenda before or during the governing board's consideration. So for instance, you typically go into closed session before your extended open session. So you must allow members of the public to make public comment on those items on the closed session agenda before you adjourn to closed session. And then for the open session, you provide them the opportunity to make public comment prior to starting the rest of the meeting. There are certain districts where they literally have public comment before each item, and actually community college districts are required to have public comment period before each item on their open session agenda.
Excuse me, I have a question. I don't know why, but I just thought of this, but if someone has a question about the closed session, but they're not here, then they want to just use that as a general, can they do that?
Yeah,
Or- Okay,
Yes, because when in your open session, that is your general public comment. And so they are allowed to speak about
Okay.
something that falls within the subject matter jurisdiction of the board.
okay, thank you.
But obviously, the board may have taken action already on the
Right.
item.
Okay, thank you.
Again, every regular meeting agenda shall provide an opportunity at some point during the meeting for the public to address any item of interest. And I know you all have a very clear delineation of that here. You have a card for agenda items and a card for non-agenda items. So you guys do a great job with that. And then you also need to ensure that you have rules and regulations in order to ensure the proper functioning of the meeting. One thing that has to be clear, and I think you guys have experienced this, is that you cannot have any sort of rule in place that prohibits any member of the public from criticizing the policies, procedures, programs, services, and even the employees of the district.
We're actually going to fix that, but yes.
Responses to public comments. The Brown Act limits board members' responses to the public comments at any public meetings. Board members and staff may only, one, briefly respond to statements made or questions posed by persons making public comments, ask clarifying questions, or make brief announcements, provide a reference to staff or other resources for factual information. And finally, and I think you all do this, request staff to report back or place a matter on the agenda of a future meeting.
So on a public comment, you can briefly respond to if they had a question, or are we refrained from?
Briefly.
Briefly.
And then it is a very slippery slope, because the one thing you can't do is engage in a back and forth,
Gotcha.
right? If you feel that there has been a factual error, you may want to make a brief comment about that. But again, you can't engage in a back and forth with a member of the public.
Okay, great. Thank you.
Willful interruption of meetings. Hopefully you all don't have to go through this, but if a meeting is willfully interrupted so as to render the orderly conduct of the meeting unfeasible, an order cannot be restored by the removal of those individuals who are interrupting the meeting. The board may order that the entire meeting room be cleared out and continue the session. The only individuals that would have to be allowed to return would be members of the press. And you would only be able to consider matters on the agenda. You know, you can't clear the room and say, well, now we can add a new topic to it. Obviously, we know over the course of the last few years, there have been some lively board meetings where this has occurred, but hopefully we've moved past that, but wanted to make sure you were aware that the board has this right. All right. So prior to closed session, the board must disclose in open session the items to be discussed in closed session. You all obviously provide a copy of your agenda to the public here. It's also posted. And so they are informed of what is going to go forth in closed session. This is my visual for essentially what can occur in closed session. These are your main topics for closed session. So first would be to discuss existing or anticipated litigation. It would be to discuss public safety threats, certain student matters. As you know, we've had discussions regarding expulsions, individual personnel matters. Employee privacy rights allow for us to have that discussion in closed session. I should bring up that employees do have a right to have certain matters heard in open session, but they have to make that request. The board would hear the matter in closed session. And even if an employee made the request to hear a certain matter in open session, the board still has the right to have their deliberations regarding that matter in closed session. Consultation with real property negotiators. And then of course, the last one would be consultation with your labor negotiator when you all are negotiating your various collective bargaining agreements with your local units. Any questions with regard to topics for closed session? All right, as to who may attend closed session. So under 54.957B, there's not a real limit as to who the board may choose to advise it when it is conducting meetings involving employment matters. However, the general rule, and this comes out of an attorney general opinion, is that closed session access is permitted only to those individuals that have an official or essential role to play in the closed session meeting. It was not the intent of the legislature for anybody to be able to attend closed session. It really should be the board, negotiators, council, and the essential district staff members. After closed session, the board must reconvene in open session prior to any adjournment and report out any action that is taken in closed session, including the vote or abstention of every member present. Those reports may be made orally or in writing. I know your typical practice is to report them out orally. A
I have
person,
a question
Sure.
about actually the previous slide. So in closed session, for example, when we do the votes, so will people know who voted what, or is it like a cumulative.
So if it is unanimous, obviously
Yeah,
you would vote unanimous, but technically speaking, you would report out, board member, Nguyen voted yes, and, Mr. Sanchez voted yes, and if somebody else no, or if somebody abstained, you would report it out in that fashion. That is the technical rule. As it relates to information and documentation received in closed session, a person may not disclose any confidential information acquired by being present in closed session to any person that is not entitled to receive it. So for instance, if for some reason I was not present and you all had a discussion about certain litigation, it would be permitted for Mr. Nehan to share that with me because I am entitled to attend closed session for that particular topic. But you are not to share information with someone who should not have access to that information and should not be entitled to receive it. I want to make sure it's clear, though, it's not a violation for you to share information on these limited exceptions. If you are making a confidential report to a district attorney or grand jury concerning a perceived violation of the law, not just Brown Act, but a violation of the law, express an opinion concerning the legality of actions taken in closed session, disclose information that is not confidential information, and disclosing information under the whistleblower statute. So those are very limited exceptions to the confidentiality rules.
So I have a question. Oh, go ahead.
sorry.
No, you first.
Okay, so I have a question. At times people may come into the closed session. So before they even come into those seats, are they told you cannot disclose information, or they're not bound by closed session info?
They are, anyone who attends is bound by.
But do they know that before coming into the room?
Give me an example of someone who you believe may not know that. I would
So
presume
for
the staff,
example,
I would presume the staff knows that.
well, no, I'm saying, so we had parents and community members come in a couple months ago
I would
to
say,
talk about closed session, and I would not know, or I don't want to assume that they know this info. So I'm just wondering who's telling them that when they come through those doors.
That was a hearing and they requested that. So
But isn't that still closed session?
it is closed session for us, but they could go out and say whatever they want because I don't think they're bound by the closed session part of that.
So they can just
Hearing
spill
we
all the
had.
beans of that 30-minute conversation?
no, so they should have been told, and I obviously am privy to one of the situations. And so I would say in that situation, I believe they were aware that it was a confidential conversation. This is general. This doesn't just apply to the board. The code session says a person. It doesn't say board members. So anyone who attends closed session technically is not to share confidential information.
An attorney-client information would be confidential, deemed confidential.
That is correct.
So if somebody was in closed session that's authorized to be there, then came out of that closed session and in the public disclosed something that was discussed in that attorney-client area in the closed session would be in violation, correct?
Technically, yes, it
Yep,
would be a
okay.
violation.
And what happens with the violation?
So we will.
Oh, you'll get to that.
Yeah.
So for example, just going back to the folks that are in the room, and it was a hearing, yes, but let's say someone learned that and 3 days later on Facebook, someone was like, oh my gosh, guess what happened? That's a violation.
Technically, yes, it would be a violation.
Technic- Okay,
Yes. I mean, what ultimately I will say is it is hard for enforcement of that, right? Especially when you have various people in the room in terms of trying to be able to determine who shared the information. There are instances where, there's only 5, 6, 7 people in the room. And so it's a little bit easier to determine who may have shared the information, but in a situation like that where there are quite a few bodies, it would be difficult to make that determination.
And just another question on the attorney client privilege that we have with you being our general counsel. Isn't it true if I come out and I say something, I could potentially be waiving our attorney-client if I disclose that out to the public?
Someone could make that argument. Obviously, as your attorney, I would argue that you as an individual don't have the right to waive it, but they would have a reasonable argument that.
To pierce our attorney, they would argue to pierce our
Yeah,
attorney-client.
they would argue that it was waived because it was disclosed.
And so we should not do that
Absolutely.
at all costs. Okay. I'm clear.
In terms of what are some of the penalties? So penalties can be civil remedies such as an injunction, a mandamus or declaratory relief are available for future, to prevent future and further violations of the act or to determine the applicability of the act to the action or threaten future action. And so what I have seen in the past when there has been violations, someone essentially it is filed with the district attorney. It essentially turns into a lawsuit, and some of the injunction can include limiting the scope of what you can discuss in closed session. There's been as extensive as trying to force boards to actually have to record what occurs in closed session to ensure there's no violations. There are penalties for violations, especially for repeated. What I've seen the most is when a district engages in repeated violations is when it usually turns into some sort of litigation. Of the laws that are new that I wanted to make sure I touched based on with you in this social media age. Back in September of 2020, AB 992 was signed into law, became effective in January of 2021, and amended code 54952.2. Essentially, what this allows you to do is it allows you to communicate with the public through social media apps and not be concerned that it would be considered a meeting outside of an open session meeting or that you are engaging in a serial meeting. There are some restrictions to ensure that you don't engage in a serial meeting, but first you can see you're allowed to engage in separate communications on an internet-based social media platform to answer questions to the public, provide information to the public, and also, and I see this a lot from board members, to solicit public input on matters within the board, right? It's kind of the quickest way that you can talk to your constituents all at one time without having to be somewhere. You can do it from the comforts of your home and receive the public input. However, a majority of the board may not discuss amongst themselves business of a specific nature before the board by the use of digital icons that express reactions to certain communications. You can't forward certain posts and make comments on it. Be careful with your likes and your, your thumbs up and your thumbs down on certain things. It would be considered a communication. Also cannot directly respond to a social media community made, posted, or shared by someone else. So again, if Mr. Sanchez reposted something, you can't comment on that. I wouldn't use digital icons on that. Of course, you can follow each other, you can look, but just be careful. Just think of it as a, you can't engage in the same way you don't want to hit the reply all. It can be looked at in that same fashion. All right, and the last sort of new addition, and this came out of the pandemic, is AB 2449. Obviously, for quite some time, everyone was participating in meetings remotely. We are back in person. but the law is slowly trying to catch up with technology. Typically, the traditional teleconference rules allow for you to participate in a board meeting via a telephone. I give a great example of, when you had to do that, let's say you were in Massachusetts, you would have to post the address of the location that you were at. You would also have to leave the door open. So if you were at a hotel, you would have to leave your hotel door open so that it was open to the public. I actually had a client many, many years ago who was on the East Coast, posted where they were going to be, participated in the meeting, and actually had someone show up to the hotel room and participate in the meeting for a little bit. They actually happened to be in the same town at the same time and participated. So that is what was required and is still required under the traditional teleconference rules. However, the law is catching up, and after COVID and all of the remote meetings, they have allowed for a little exception to allow a minority of the board to participate remotely if necessary. And there are very clear and specific conditions that must apply. So first and foremost, there has to be a quorum of the board present in person at a singular location, and it has to be open to the public, and it has to be within the boundaries of the district. So essentially, 3 of you would need to be here for a regular meeting. If all of that is true, then 2 of the members are allowed to participate remotely. You could be in Cancun, but these particular rules would have to apply in Cancun. So the 2 individuals participating remotely would have to, one, either participate in a 2-way audio-visual platform, Google Meet, Zoom, Microsoft Teams, or a 2-way telephonic service. And then the district would have to ensure that the meeting was being live cast on platforms such as YouTube or YouTube TV. Now, you would have to be attending remotely due to just cause or emergency circumstances. And there is definitions provided for both. Just cause is childcare or caregiving need of a child, parent, grandparent, grandchild, sibling, spouse, or domestic partner. Just cause is also a contagious illness that prevents the member from attending in person. A need related to physical or mental disability, or travel while on official business for the board or for the district or another state or local agency. And emergency circumstances are defined as a physical or family medical emergency that prevents a member from attending in person.
I didn't see Cancun on that list.
Yeah, kind of hard to fall in one of those categories.
Jabari,
yes.
just before you move on, question about the public comment, the 2 slides ago. So are we, or is the public allowed to make comments via phone right now?
No.
Or they have to be in person?
Because
for-
you all are now, your meeting is completely back
Here.
in
Oh, okay.
person.
But if one person was remote, then we would have to allow it
I mean,
digitally?
technically, I think they could try and make that argument. They didn't really specify that. I think
Oh,
because you
okay.
have a quorum here, I
Ah,
think you're still in a
You still-
position
okay.
to require.
so somebody couldn't just then
Right.
do the, okay, thank you.
Yeah, I mean, the intent is for all of the meetings to be back in person. This is really because of the pandemic and knowing that maybe someone could still potentially test positive. They provided an opportunity where someone could still participate remotely. So. However, I want to make sure it's also clear that this exception, you can only participate remotely due to just cause or emergency circumstances for 3 consecutive, or cannot participate for more than 3 consecutive months or 20% of the regular meetings in a calendar year. So someone can't come up with just cause or emergency circumstances every single meeting. A member, you may still participate under the traditional teleconference rules outside of this, but you have to comply with those rules, which, as I noted, you would have to post the address of your location. And the just cause exception cannot be used by any member for more than 2 meetings in a calendar year. They also ask that you request approval as soon as possible so that the district and the board can take the appropriate action to approve the request. You have to provide a general descriptions of the reasons, and they needed to be provided on the agenda. And if you, for instance, if you're at home and you are taking care of a child or a parent, and they need to be in the room with you, you do need to indicate whether or not anyone else is in the room with you, and the general nature of that relationship. And anybody who is participating remotely is supposed to participate both audio and visual technology. If you're using this, if you want to do traditional teleconference rules, you could be just on the phone.
So we have to be able to see the person and they have to be able to see us?
Yes.
Oh,
When did this law take place?
It just
That's
came
interesting.
into effect in, I want to say it was, might have been January of this year, I believe, 2023.
Oh, so it's very.
Yeah, it's
Hmm.
brand new.
Hmm.
It's essentially like post-pandemic. I think that is my final slide. I tried to pare it down. I knew we were on a tight timeline.
As always, you did an outstanding job. Good job.
Are
You got
there
any
any
questions, anybody? Go ahead, Ms. Wynn.
Is it possible to get a copy of your presentation?
Sure, and I think I'll
Thank
talk
you.
to Sue Nehan. There were some things, because I wasn't sure how many questions we may have, that maybe I will insert just to make sure all things are covered.
It's just that you presented so many good points and I just would like to have this as a reference.
Okay.
Thank you.
Absolutely.
So, I read, or I saw the slide of, 3 people can be at events or whatnot. I guess my question is perception. You as our council, do you just advise us, just stay away from each other? I mean, I know we need to live, but, where do you feel we should think about our boundaries of these like social or dinners, or we're going, if 3,
So legally, we get it, just, but it's more of a perception.
yeah, yes, because I'm just speaking for Antelope Valley Union High School District. You as our attorney, what is your recommendation for us?
So
I mean, should I go unfriend whoever I have on Facebook?
Well, one, I don't want to give you legal advice in public. But I would say as a general rule, if you are somewhere socially, right, it is okay. Everyone should enjoy life, go to events, different things. But I would say, yeah, obviously it's going to be perceived in a certain way if 3 or more members are huddled together at an event talking for an extended period, right? I mean, and some of the things are very, I like to refer to them as commonsensical, and it's, in terms of 2 members standing around. Technically, under the Brown Act, you're allowed to have that conversation. You can talk district business amongst 2. The issue becomes when the 3rd or 4th or 5th person comes along. So don't refrain from going anywhere because Ms. McGrady and Mr. Hughes might be there, right? It's just a matter of probably if you're going to an event, maybe don't all sit at the same table. Okay, all right.
Been a closed session. Number 3, are there any comments from the public on closed session items?
Have no comments on closed session items at this time.
All right, we will move into closed session. And we'll be back at 6:30.